A federal court of appeals answered two questions. Number one, does the Second Amendment protect purchasing guns? Number two, does the Second Amendment protect owning more than one gun? I'm sorry, I can't finish that without chuckling because it's crazy, but it's not half as crazy as some of the arguments that you are going to see the government muster to try to shut down the Second Amendment in this video. So guys, let's get into it. Imagine if this was any other right. How many unreasonable searches and seizures can you meter per month? In other words, how many can you deter or stop per month? Or alternatively, how many times is the government allowed to unreasonably search and seize you per month? How many times are you allowed to protest per month? How many times are you allowed to worship per month? How many times are you allowed to read or write political speech per month? Can the government meter how often you're allowed to vote? Per year? Per decade? How crazy would those sorts of arguments sound if we were talking about anything else than Second Amendment? If you're anti-gun, then you would say, yeah, that's totally crazy, but that's totally reasonable when we're talking about guns. If you're part of the circle here, then you're probably going, yeah, that all sounds the same to me. Corporate asked me to distinguish between these two pictures, and they're identical. Right. Now, of course, anti-gunners say that this is different because guns are dangerous and they kill people. So we need to limit the purchases out there in order to prevent violence. I've got news for you. Books and ideas have killed more people in the last 100 years than any amount of firearms privately owned by Americans. The judges actually asked this question to the anti-gun lawyers from the state of California at oral argument about how often are you allowed to meter and crush other constitutional rights? Just wait until you see how that played out. Now, first, this lawsuit was brought in part by the Second Amendment Foundation, SAF, Firearms Policy Coalition, FPC, as well as the San Diego County Gun Owners, PAC. All fantastic groups. Be sure to check them out, support them if you are not. Everybody should be a member of at least one or two organizations. I say as many as possible, but at least one or two. This case fundamentally challenges the California law that forbids law-abiding citizens from purchasing more than one firearm per month, or that's one gun per every 30 days. Yeah, that's the law at question here. They actually passed that. Now, this used to only restrict handgun purchases, but it was expanded, imagine that, in 2024. Now, we're in the Ninth Circuit Court of Appeals. We're going to cover this when it went through the trial court. The Ninth Circuit, it's not maybe what you remember. You see, Trump gave the Ninth Circuit Court of Appeals what the kids like to call a glow up. Gone are the days when this Federal Circuit Court of Appeals was regarded as a super fringe, politically left group. Don't get me wrong, it's still politically left, but not nearly as much as it used to be. The Ninth Circuit, for those of you who don't know, basically covers America's West Coast states. So in addition to that, we're talking about Alaska, Hawaii, Nevada, Arizona, Idaho, Montana, and of course, we're talking about California, Oregon, and Washington State. Sorry about that, Bill. There are 29 active judges on the Ninth Circuit. 16 of them are appointed by Democrat presidents. 16 out of 29 appointed by Democrat presidents. 13 have been appointed by Republican presidents, but mainly from one man in his first term, and that would be President Trump. So 13 from Republican presidents, 10 of them from Trump's first term. 10 out of 29 are Trump appointees. So the way that this works is when you appeal up to a federal circuit court, they will typically just do a random grab of, hey, 3 out of our pool. The pool for this one had 1 Obama-era judge and 2 Trump-era judges, okay? So you can predict the outcome that this may be going in. And if you can do that at this point, congratulations. Give yourself a hit of that like button and leave a comment down below if you nailed this as to where it's going. But first, really quickly, what's the law? So how are judges to decide whether or not a law that's regulated the Second Amendment is constitutional or not? Well, in June of 2022, the United States Supreme Court, in a case called the Bruen decision, B-R-U-E-N, laid out a test that says, hey, this is going to be a ball, this is a strike, okay? This is going to be an okay gun law, if there is such a thing, and this is going to be an illegal, unconstitutional one. It's basically a 2-part test. Number 1, does the law or regulation in question affect an area controlled by the plain text of the Second Amendment? Like, for instance, owning or buying a gun. And then number two, whether the burden can be justified by the nation's historical tradition of firearm laws and regulations. So in order to do that, the government, the people doing the anti-gun stuff, has to find a sufficiently similar law from our nation's history of firearm regulation. Now, importantly, the Supreme Court has said that, look, not all eras of laws are created equal. Okay, so if you're pro-gun, you want to go back to the founding era. You want to go back to 1791 and back all the way through the early republic, 1830s. If you're anti-gun, you want this coming from like yesterday, and particularly, maybe the 1990s to 2000s or something like that. And I actually have heard anti-gun politicians argue that the 1990s should count. At least as of today, no serious lawyer is advocating for the 1990s. The most I've seen advocated for in court basically goes up through the early part of the 20th century, so the early 1900s. But the most I see argued in federal circuit courts is what we see here. We go up to about the year 1900. And that's important because after the Civil War, so we're talking 1865, we then had the Reconstruction era, and then in the 1870s and beyond, we started to see an explosion of gun laws take place both across the South as part of Jim Crow, but as well as in the Northeast, perhaps in response to perceived immigrants coming in, bringing threats and anarchy and all this other kind of stuff. So you saw all these sorts of things start to work their way in there and gun laws explode. So it's really important that we pin down which era the court is allowed to draw from in order to determine whether or not, hey, what is the American tradition? And does this law fit that tradition? So first, we can start at some place where even diehard anti-gunners can agree. Question of, is trying to purchase more than one firearm per month protected by the Second Amendment? California says no. Quote, California suggests that the Second Amendment only guarantees a right to possess a single firearm, and that the plaintiff's rights have not been infringed because they already possess at least one firearm. California is wrong, end quote, wrote the judges in the majority decision. Gotta love that. California is wrong. Can we get that on a bumper sticker? The Second Amendment protects the right of the people to keep and bear arms, plural. It is in that text that we can simply say, by looking at, that little S after arms, not keep and bear arm, but arms, okay, that yes, we're allowed to have more than one. Also, not to mention the fact that, hey, can you only protect one spot from unreasonable searches and seizures? Are you only allowed to have one religious book or one political book or something like that? Again, this is where we got to this whole topic found in the opinion, which is linked down in the description box below, of so-called metering. The government's arguing that you are allowed to meter the Second Amendment. In other words, you're allowed to restrict the flow of it, and that's still going to be fine. So we know that's going to be covered. Let's take a look at some of the other bang-up arguments brought to you by the great taxpayers of California, whether they agree to it or not. I'm going to focus on three of them here. Argument number one, California argued that the laws were designed to reduce gun trafficking, especially so-called straw purchases, limit the stockpiling of weapons that might end up in illegal markets, and provide law enforcement with tools to monitor suspicious purchasing behavior. The court responded that, look, under the Bruin analysis, policy goals, maybe even admirable ones, like we don't want to arm gangs and cartels and so forth, do not justify a law that burdens conduct covered by the plain text of the Second Amendment, unless, of course, backed by history and tradition. But public safety alone is not sufficient justification to step on the Constitution. Number two, California argued and contended that the restriction was a modest limit. It does not ban firearm ownership, it just meters the rate of consumption. The court answered, we are not aware of any circumstance where government may temporarily meter the exercise of constitutional rights in this manner, end quote. Even a modest constraint on the frequency of firearm purchases impermissibly restricts the right to acquire arms. And number three, the state argued that the law is kind of like a waiting period and a cooling off period for when you go to buy a gun. In some states, they say, hey, you have to wait 2 weeks, 2 days, something like that. The court said, no, it's not like that at all. Quote, waiting periods impose a delay on acquisition, not a recurring categorical cap on how many arms a person can buy. The one gun a month rule is far more burdensome, end quote. I mean, as a perfect example, if you go to buy 100 guns and you still have to sit out your 48-hour waiting period, at the end of the 48 hours, you still have 100 guns. At the end of the one gun a month, you're metered at maybe 12 guns per year. Last I checked my math, I'm not in California. I think things work a little differently out there. And by the way, in response to what I teased at the intro, when the judges asked at oral arguments for this case, what other rights are allowed to be metered the same way that California, you guys, are asking to meter the Second Amendment? Their response, nothing. No answer. Shocked. Where does this go from here? Well, my guess is that since the Ninth Circuit Court of Appeals still leans left, it's not the most left, but it still leans left, is that California will petition for what's called an en banc rehearing. In other words, we're going to get the whole band back together. And we know that the circuit will lean left, so we'll get the decision that we want because we just happen to get, from their view, we got 2 Trump judges, 1 Obama judge. So, hey, we're going to lose. That's a bad shake. The only problem with that theory is that the Obama judge went along with it. This was a 3-0 decision. The Obama judge and the 2 Trump judges all agreed. Where will California go next? Ball's in their court. Be sure to hit that like button, subscribe. Let me know down in the comment field below what you think about this. Where is this going to go? Does this go to the U.S. Supreme Court? Does it get ultimately struck down? Will California just do what anti-gun states do and they move the goalposts? Here comes your quote of the day. This one's from James Madison, who back in 1789 said, quote, "The right of the people to keep and bear arms shall not be infringed. A well-regulated militia, composed of the body of the people, trained to arms, is the best and most natural defense of a free country." End quote. We'll see you in the next one. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.